All right. Go ahead.
So as I recall, what the testimony was, Mr. Warren, you were at the trial, that Elking and Boyd were sitting on the front porch. Two perpetrators came around the side of the building. So at one time it was Boyd and Elking on the porch. The two perpetrators went up on the steps and shot Boyd, who was on the porch. You agree that's what happened?
Well, I'm not sure it was that cut and dried. I think there was some discussion or argument between Marcus and either Lamar or Philip Campbell.
And Judge, for clarification, I believe that is an oversimplification of the facts.
Well, you're right. It's now cleared up.
Okay, so we got a dispute, I guess, as to what happened on that porch, but that's okay. Were there four people there?
Let me make your life easier.
Sure.
If you wish to dispute the testimony of either Mr. Elkins or Bowen, was that his last name?
Howard.
Howard.
James Howard, Your Honor.
James, I don't know where the name Bowen came from. Of either Mr. Elkin or Mr. Howard. If you want to dispute the testimony of those two fact witnesses, all right, the time to have done so would have been in their cross or by putting on a witness from the stand who is competent to contradict him. Since this witness, of course, wasn't there, all you can really do is, if there are predicate facts that this witness needs to agree to in order for you to tee up a relevant question, that's fine. Lawyers do that. However, if your only concern is to have the facts asserted in your request for stipulation of facts to be agreed to, I think at this point in time, if you can't work it out directly with them, then that means they're going to put you to your proof. And I don't know if you can get proof from this witness.
Your Honor, I agree. I'm just, I don't dispute the testimony of Elking and James Howard. They testified what happened.
You what?
I don't dispute the testimony of Greg. He goes by Greg Elking. Everybody knows that. His full name is James Gregory Elking.
So what might be easier is to simply ask him a "were you aware at the time" type of question. Because he may not have been aware.
I will ask him a simple question. Were you aware at the time of the trial what actually occurred on that front porch?
As related to me, I was not an eyewitness.
Okay. Yeah. Judge, I'm not going to spend more time with Mr. Warren to direct simple facts that I think the testimony in this case
Speaks for itself.
Speaks for itself, correct, Your Honor. So I only have a couple additional questions. So after the trial and conviction of Mr. Lamar Johnson, did you learn that Philip Campbell actually signed sworn affidavits saying he was involved in the crime and not Lamar?
I found that out when this all started unraveling in 2019. I then found that he had made a sworn statement to the judge that he, Philip Campbell, and Lamar Johnson were the shooters. This was sworn under oath to the court before this affidavit, which materialized 10 years later.
You're referring to when he pled guilty, right? Campbell pled guilty.
Yes, sir.
Yeah. And that transcript, they've got to ask you about that, and we'll look at that transcript.
Okay.
But other than that, did you learn that that Philip Campbell had filed sworn affidavits subsequently to his sentencing? That he...
Not until approximately 10 years later.
Okay, but you did learn that he had filed affidavits.
Sure.
Claiming that he was participating in the killing of Marcus Boyd along with James Howard.
Signing that affidavit did not make it true. But yes, he did sign a document to that effect.
You know, I have a question. I need to think for a minute if I think the question has any real relevance. And given your years as a prosecutor, I guess your answer could be anticipated, but I just want to ask you, are you of a mind that in a case this serious, there can be no concerns about absolute innocence if the people who say that a defendant was innocent are all people with criminal histories? Because some people are of that mind, and no crime in thinking that way. I'm just curious as to where your head is.
Well, it was a multi-part question. Am I of the belief that pure innocence should establish exoneration? Absolutely.
But what about when the evidence just comes from people who have criminal histories?
Well, I think just like a jury, I would need to determine their credibility. And if they have prior convictions, that, according to the rules, can be used to determine their credibility. And the fact that there is a conflict between an affidavit 10 years afterwards versus 6 months after the event, 6 months after Lamar's trial, yes, I would think that that's to be weighed. The fact that B.A. comes in also 10 or 20 years later. Number one, he was underage at the time. He could once he got a life with no parole, he could not get a single day more in jail. He couldn't get the death penalty because he was of underage. And on top of that, he was of probably the stature of any normal 16, 17-year-old kid, which should not have been confused with that of the stature of Philip Campbell.
So you basically would have dismissed witness Howard on the grounds that he has absolutely nothing to lose by lying. That's how you would look at it.
In addition to which, he was established to be a childhood friend of Lamar Johnson. And that affects his credibility in my eyes.
All right.
Your Honor, at this time, I'd like to just move for admission of Exhibits 82, 44, 183-1, 183-1. Let me start out again. Exhibit 82, 44, 183-1, 183-20, 158, 159, 160, 162, 163, 164, 166, 167, 168, and 169. Those are all the exhibits that we showed to Mr. Warren this morning.
Okay. I think you hit everything on my notes, but counsel for the Attorney General's office, any objections to the admissibility of those exhibits? All right. You may consider them all to be in evidence.
The only comment I have, Your Honor, is Mr. Warren, when his testimony is over today, would like to stay in the courtroom. We do not intend to call him a rebuttal, so our examination of him, I have to cross.
You said you have no objection to him staying in the courtroom.
We have no objection to staying in the courtroom.
All right. We'll see how the Attorney General's office feels after their examination is over. Counsel for the Attorney General's office, you may proceed. You may.
Use the microphone. You want to use the microphone?
Counselor?
Thank you, Your Honor. Good afternoon, Mr. Warren.
Hello.
You testified that you were an assistant circuit attorney at the circuit attorney's office back in 1994 and 5 as the chief homicide prosecutor. How long were you employed with the circuit attorney's office?
Approximately 40 years.
After your 40-year stint with the circuit attorney's office, did you continue practicing as a prosecutor elsewhere?
In 2019 or 2020, I became an assistant prosecutor for Butler County,
Okay.
Missouri.
Are you still employed by Casey Proctor, the prosecutor there?
I am.
All right. So how long in total have you been a prosecutor, sir?
Well, 50 years, no, that includes the police time. 45 years.
Okay, and you
At
said
least.
that includes the police time. Were you employed prior to being a prosecutor in law enforcement?
Yes, I was a police officer for the city of St. Louis while I went through law school.
All right, and how long were you employed with the City of St. Louis Police Department?
4.5, almost just shy of 4.5 years.
And Mr. Warren, you testified about the process that you would undergo whenever you're reviewing a case for requesting a judge issue a warrant. Is that correct?
Yes,
And so your testimony was that and correct me if I'm wrong, a detective or officer applying on the case would come to you in your office. Is that right?
I'm not sure I heard you.
Your testimony was that a detective or officer applying for the warrant on the case, they would come to your office
Yes,
and they would bring whatever information they had.
yes.
And it was common for them to either bring a witness or victim along as well. Is that correct?
I heard it was common, and then I didn't hear.
I'm going to try better to speak directly into the mic.
Slow it down. That'll nail it.
Thank you, Judge. You said that it was also common for the officer or detective to bring with them either a victim or witness involved in the case. Is that correct?
Is that for the warrant application, or are
Yes.
you still talking about the search warrant?
No, I was only ever talking about the warrant application.
Okay, yes.
And whenever you would meet with these individuals at the warrant application, you would have an opportunity to speak to them alone?
Yes.
And that was at your discretion?
What's that?
Was that at your discretion?
What's that?
Were you required to meet with them alone, or was that at your discretion?
No. I mean, sometimes I would, sometimes I wouldn't.
In 1994, October of 1994, approximately how many warrant applications had you completed?
From beginning to then,
From the beginning of your time as a prosecutor to then?
I don't know, 5,000, 10,000?
Okay. So is it fair to say that you had met with thousands of victims or witnesses and assessed their credibility?
Oh, yeah.
And on November 5th of 1994, you testified that you met with James Gregory Elking at the Circuit Attorney's Office.
November the 5th, what?
1994. I think I might have said 5.
What was I supposed to have done then?
Is that the day that you met with James Gregory Elking in your office?
I had James Elking in my office on that, I guess on that date. I don't have a calendar in my brain.
And you testified that you spoke with him individually?
Yeah, well, yes, directly from me to him. Was anybody else in the room? I don't remember. I'm trying to think. This was 1994. Where was my office? My office was, I think, just in this building. We just moved.
Okay. And so you had an opportunity to meet with him,
Yes.
ask him questions,
Oh, yes.
assess his credibility,
Yes, ma'am.
and at no time during that meeting did he falter in his identification of Lamar Johnson.
That's correct. He explained why he had not identified anybody in the lineups.
And he explained to you that he was fearful. He was fearful.
Fearful, yes, yes.
And based on your conversation with Mr. Elking, you felt confident in his identification to move forward on prosecution of that case.
Yes.
And at no time...
Hold on. If you're going to go down that line, because the wording of your question probably implies a lot more than supported by the facts developed at this point. Because you were dealing with a witness at that time, is it not true, who's only basis for identification was recollection of something in the eye that he thought was a little different than normal.
Yes, sir.
So there was nothing else.
He was positive.
That wasn't my question. There was
Well, I'm not
nothing else.
understanding your question, Judge.
There was nothing else. Was there anything else besides, I see the eyes and I think that's the person? That's my view. Anything else?
The fact that he was admitting that he was there for a drug deal?
No, that wasn't my question. I mean,
Well, you asked if there was anything else, and I
we're talking about
enumerated that.
identification.
Yes.
All right? Identification.
Which goes to his
When
credibility.
he made his identification, I didn't ask that question.
I'm sorry,
When
I'm
it
not
came to
following
his
you.
identification, he told you and the officers that it was based upon him looking at the eyes because that was all he could see. Isn't that correct?
I believe so.
And he told you this based upon an identification that occurred in the middle of the night. Isn't that correct?
Middle of the night, 10
Yes,
o'clock or
9
so?
o'clock at night.
Okay, I wanted to make sure that you and I were on the same wavelength
9
as to
o'clock
what
at night.
middle of the night meant.
9 o'clock at night.
Okay.
And did he or did he not tell you that all of this happened, I believe, as he described to the court, within seconds?
Yes. Yes.
And that's what you decided was sufficiently liable to seek a murder conviction.
To take it to a jury. Yes, sir, I did.
Oh, because as you told me, let the jury decide.
Well, I'm hearing the fact that you don't find that credible in your tone of voice.
I'm asking you a
That's what I
question.
did. That's what I did
I'm asking
because
you a question.
I did not believe that, believing the witness, that I should just ignore the fact that he was positive of his identification and let a murder suspect go. That's why I came to my conclusion.
All right. Because when I ask you open-ended questions like this, you have absolutely every right to fully explain. Because that's what I'm looking for.
That's what I'm trying to
You
do.
make it too hard.
Thank you, Your Honor. And you testified either yesterday or today on direct examination that you attended a deposition for Mr. Elking. Is that correct?
Well, I would say so, but I don't know what you just asked.
Did you
Can I
test?
see your lips as well
Does
as
that
your...
help?
Yes.
Okay, is this better?
Yeah, I think.
All right. Did you testify that you attended a deposition for Mr. Elking?
Yes.
Okay. And during that deposition, was he asked, if you recall, was he asked if anyone told him who to pick in that lineup?
I would believe so, if not by me, at least by David Bruns.
Okay. And during that deposition, if you recall, was he asked about the timing in which he identified someone?
I don't know. The deposition would speak for itself. I don't recall line by line what was asked and answered.
Okay, but you were present for that deposition?
Yes.
May I approach, Your Honor?
You may, counsel. Assuming to refresh recollection.
I was going to show him the deposition transcript, Your Honor.
All right. But I'm assuming it's to refresh recollection.
Yes, Your Honor.
All right.
I'm going to show you what's been marked for identification as State's Exhibit BB. And I'm going to point you to page 38, starting at line 25, and then going on to page 39, stopping at line 12. I'll ask you to read that.
Yes. Stop there at line 12. Okay.
Yes, sir.
Yes.
And does that refresh your recollection of what was asked and answered at that deposition?
Yes.
And what was Mr. Elking's answer whenever asked about when he identified who was in that lineup as Lamar Johnson?
I don't recall exactly what he said. It was after line 12. And I didn't review past line 12 at your instruction.
Are you trying to say you don't remember what was said?
Yes, that's what I'm saying.
Do
I
you
know-
think looking at that transcript will cause you to remember?
Yes, sir.
All right.
Would
Did
you like to
show-
review it again, sir?
No.
May I approach, Judge?
You may.
Thank you. And just, I'm going to re-ask the question before you review this. My question to you
Well, you know, the appropriate tactic is to simply let him look at it, and then you inquire as to whether his recollection has been refreshed. Now, you can direct him to a particular line.
Well,
That's
Judge, I
fine.
think he might have forgot the original question that I posed to him, which was, at what point did Mr. Elking tell Detective Nickerson who he was identifying in the lineup?
Oh, I did not realize that was your question.
Okay.
After the lineup, I don't know that he specifically said where he was, but it was definitely after the lineup when he said that to use Charlie's phrase, F-upped. He said, I actually know who did it.
Okay, and that was after the lineup, they were no longer in front of the in-person lineup, is that correct?
Correct.
And do you recall if Mr. Elking was asked that same question at trial?
I believe he was.
And do you remember what his answer was to that question at trial?
You have the trial transcript there with you?
I do, Your Honor.
All right.
Again, 20 some odd years later, 26 years, I don't have an independent recollection, but I do know that I reviewed the transcript and that was accurate.
Okay, would it help refresh your recollection to review a portion of that transcript?
Yes.
May I approach, Judge?
You may, Counselor.
I'm going to show you, beginning on page 170 of the trial transcript, starting on line 17, and continuing to line 17 on the very next page. Does that help refresh your recollection?
Yes, ma'am.
Do you need me to re-ask the question?
Please do.
Okay, so my question to you was Mr. Elking asked at trial when he told Detective Nickerson about who he was identifying in the lineup?
The same thing he said in the deposition. That was after the lineup.
And
I think he said in a room.
Did he indicate why he waited until after the lineup at trial?
He felt that he was intimidated by the people that he was looking at in the lineup.
Was Mr. Elking ever identified in police reports by name, to your recollection?
I don't think so.
Was he treated as a secret witness by the state?
Yes, when he had his deposition, for example, the deposition was titled Deposition of Secret Witness. Maybe had a first name, I'm not sure.
And do you recall at any point there being a motion to compel for the identity of secret witness throughout the course of the prosecution?
I don't remember that, but I would have opposed it.
And if there was a motion, okay, so you say you would have opposed it.
Absolutely.
Whenever Mr. Elking was deposed, did you produce him for that deposition?
I did.
Why?
Because I didn't want the defense to know where he lived.
At that point, had you told the defense that he was a protected witness?
Yes. Well, I'm sure I would, because that's why I went to fetch him.
I'm glad you asked that question, because I need to ask you then, before the deposition, the defense attorney would have been advised that this was a protected witness.
Well, yeah, and the fact that we were relocated him and weren't giving out his identification.
All before that deposition.
Yes.
During the course of the deposition, to your recollection, did the defense attorney inquire as to the details of this relocation, what it was about, what the witness was and was not getting, all of those matters?
Well, as to his relocation, he started to, I think, in fact, he did ask where he worked, and I objected. I think we went off the record, and he abandoned that because we talked about him being a, quote, protected witness.
Right.
And he abandoned that approach. As far as what he was promised, I'm pretty sure that was in there. Again, the transcript itself would speak.
Okay, I'll need anything wherein the defense attorney asked and sought information as to all these payments, the payment of rent, the payment of cost to relocate and move someplace else, everything that was expended for this person with respect to securing his testimony at trial. I need to know if those questions were asked and if any detail was asked.
Your Honor, I can offer as State's Exhibit VV, I can offer to the court the deposition of secret witness Greg.
No, you didn't hear my words.
I didn't
I
understand.
want just the questions. I don't want the whole deposition.
Understood,
I don't
Your
need
Honor.
the whole deposition.
I
You are
believe-
because if you don't give me the questions, I'm going to assume the defense attorney engaged in ineffective assistance of counsel. You don't want me to go there.
Your
You want
Honor.
to show me that that did not happen.
I do not believe that there are any questions in this deposition as to the relocation. I believe that Mr. Warren's memory was pretty accurate in that there was a question about where the
Where he
secret
worked?
witness worked.
That wasn't my question.
There are no additional questions in relation to the location
Thank
of
you.
the witness.
That's what I kind of anticipated, but I want to make sure that the record was clear on the matter.
And
Thank
Your
you
Honor,
for your answer.
yesterday I think you did indicate you asked for a copy of this deposition. I'm happy to offer it as State's Exhibit VV.
Yeah, offer it, but that was why I was wondering
Okay.
how, because I just heard from the state that this was essentially flagged to defense counsel, and defense counsel, perhaps out of ignorance of what goes into relocating a witness, did not delve into the degree to which one could argue that the witness did or did not receive benefit that under cross-examination before the jury could cause the jury to say, well, maybe we shouldn't trust what he says beyond a reasonable doubt, since this was the key witness.
Yes, Your
It's
Honor.
a big deal.
I will offer it then as State's
All right.
Exhibit VV.
Thank you.
Can I say something?
No. Mr. Warren, I just want
You
to...
said, can you say something?
Oh, I
You go
didn't
right
hear you,
ahead.
sir.
All right. Relocation is always going to cost money. You can't relocate a person without spending some money. David knew that we had relocated him. It's implied. It costs money. How much? Heck, I didn't even know. So I don't think that question that the judge proposed could have been answered at the deposition or even at the trial time.
It could have been asked.
Could have been
It
asked.
most assuredly
It could have been asked, but the answer would
And
have
any
been, I don't
competent
know.
judge would have allowed it under cross-examination, because it goes directly to credibility.
But the question is...
How much
can-
money did you get?
And the answer is no, and in that sense, the question is not evidence, it's only as it's supplied by the answer to the question.
Boy, are you wrong. Go ahead.
Well,
Let me ask you this, Mr. Warren. Do you recall at trial any questions being posed to Mr. Elking about him being relocated by the state?
I don't recall, but again, the transcript would speak for itself.
And as a prosecutor, the chief homicide prosecutor at the city of St. Louis, if a witness who had been relocated was asked about the relocation, would you address that on redirect examination?
Now you're getting a little in the speculative zone, because we don't know what the answer could have been. Let me make sure you understand. The defense attorney, if he has knowledge of basic reasons why the jury should not believe a key witness, has a responsibility to inquire into that. If Mr. Warren is correct, the word relocation should have triggered in the mind of Bruns the possibility of money being expended, then that's a question that should be asked. It's kind of like if a witness says, I was paid a fee. Then the person cross-examining the witness says, how much were you paid? How reasonable is that fee? And then the jury can hear this, and the jury can say, well, this relocation stuff really helped change this man's life. He had nothing. And now that he got all this relocation assistance, he got some help off to something. That's something that the jury can take into account. Any suggestion that they can't take into that account is wrong under the law. And any suggestion that those questions could not have been asked at trial is wrong under the law. and any suggestion those questions could not have been asked at deposition is wrong under the law. The issue for me is, should they have been asked to the degree that a potential constitutional violation has occurred? I think I'm clear now.
Yes, Your Honor, I
So,
understand.
Ask questions in light of that. Let's not go off on things that really don't matter.
Thank you, Your Honor. So I wanted to kind of move over, Mr. Warren. We were talking about the witness, Mr. William Mock, and quite extensive testimony about that this morning. My question to you is, back in 1994, was it common practice for you to provide your investigator with the names of witnesses you intended calling at trial?
Yes.
And do you know what system or database your investigator used to run the criminal history?
Do I know what?
What database was used?
No, it was maybe Regis, maybe Mules, I don't know. That's something that I never was able to master.
Okay. And so then after you would provide that information to your investigator, how would he give that back to you?
He would tell me, witness 1 has no record. Witness 2 has some arrests but no convictions. Witness 3 has these convictions of a felony or misdemeanor. And that would be him telling me, and then I would pass that on to the defense attorney.
Okay, and your memory is that you did that in this case? Your memory is that you did that in this case?
Yes, yes. Mm-hmm.
And are you aware if that, whatever database was used, could search criminal history nationwide, or was it statewide, or do you know?
I don't know. We used to have what was called a Hoover sheet, which was an FBI sheet, and that would have supplied some sort of federal umbrella. If they use Mules, I think that I know from personal experience recently that Mules gives out-of-state convictions, but I don't know what it did in '94. So I hope that answers your question, and I certainly want to answer it.
It does. And do you recall if at the voir dire portion of trial, if you introduced or questioned potential jurors on the fact that they would hear that witness had several prior convictions?
I believe I would have. I normally would.
Would it help refresh your recollection?
Yes,
I just
ma'am.
need to know if those prior convictions came out at trial.
Do you recall the trial testimony about his prior convictions?
Yes, ma'am.
And what was that?
Mr. Mott said that he had several convictions and he enumerated them, the same ones that I had given to Mr. Bruns. He also added, I got something in California. I don't know whether that was at the deposition or trial. And he also added, and I had some other minor convictions with the loss over the course of years. And that was what was presented to the jury.
And as far as Mr. Mock, you testified in excess this morning about letters from Mr. Mock to you that you hadn't seen, some that you recognized, and there was also the letter that you wrote to the parole board. Is that correct?
Yes.
And at the time of trial, on July 10th, 1995, had you already written that letter to the parole board, or at least drafted it?
I don't know. If Charlie could give me that paper again, I would read off the date on it.
Well, do you recall asking Mr. Mock at trial if he expected you to write that letter and inquiring if he had in fact seen that letter that you wrote?
You had compound there. What was the first one? If what?
Do you recall asking Mr. Mock at trial if he had seen that letter?
I don't recall asking him that. No.
Okay. Would it help refresh your recollection to see the
Yes,
trial
ma'am.
transcript? May I approach, Your Honor?
You may, Counselor.
I'm going to show you. Give me a second. Starting on page 249, line 24, and going on to the next page, 250, line 8.
Okay?
Does that help refresh your recollection?
Yes, ma'am.
And can you tell me what the testimony was in regards to the parole letter at trial?
He had asked me to write a letter to the Board of Parole, and that was the only thing, and I wrote it, and it was before trial.
Okay, and in fact, you had showed it to him, is
Yes.
that correct? And that discussion occurred in the presence of the jury. That's part of the trial transcript, correct?
Yes.
Can I have 1 second, Your Honor?
You have 10 seconds.
Thank you, Judge.
You need water? Oh, you got water.
Got some. I'm going through a lot.
Take your time.
All right, Mr. Warren, I just have one last question. You had testified on direct examination that sometime later, after, I believe you said after the motion was filed in 2019 and you were reviewing the file, that you saw a transcript from Philip Campbell's plea
Yes.
guilt. Whenever he pled guilty in his case, is that correct?
Yes.
And I'm going to show you, if I can approach, Your Honor.
You may.
I'm going to show you what's been marked as State's Exhibit K and ask if you recognize that.
Yes, it appears to be the transcript of, in front of Judge Berger of the defendant Philip Campbell at a plea of guilty.
Okay, and I'm going to take that from you. You had testified on direct that you didn't remember exactly what the dialogue between Judge Berger and Philip Campbell was. Would it help refresh your recollection to review this transcript again?
Yes, I remember generally, but specifically word for word, no.
Okay, and Your Honor, I will inform the court that this is not numbered, so I don't know what page number I'm going on, but I'll proffer the whole thing to the court.
You have, and should, in all honesty, isolate the pages, perhaps in your post-trial brief, that you think are truly relevant.
Yes, Your Honor. So I'm going to flag to you, I have these green stickies here. If you'll just read
Would you mind?
That's fine.
from there to there.
From where to where? Okay.
Steve.
Okay.
I'm going to ask you a question about that in just a second, but prior to that guilty plea, you were still the prosecutor on the case. Is that correct?
Up until the time I left for the military.
So on June 26, 1995, were you still the prosecutor on Philip Campbell's
No, ma'am.
case? When did you leave?
Like I said, I remember definitely flying out of the United States on Christmas Day.
Of
We would have been
1995?
active, ma'am?
Of 1995?
Yes.
Okay,
We
so
would
my
have been
question was
active
on June 26, 1995, you would have still been in the circuit attorney's office?
in June of '95. I thought you
Yes.
were talking about. Is this the date of the plea of guilty?
No.
Oh, okay. You confused me. All
You're
right.
getting ahead of me.
Okay.
So you were still the prosecutor in June of 95?
Yes.
All right, I'm going to show, if I may approach, Your Honor.
You may?
I'm going to show you what's been marked as State's Exhibit J and ask if you recognize that document.
Okay.
And do you recognize this document as a alibi defense that was sent to you by Philip Campbell's attorney, Robert Lunt?
Yes,
And this would have been part of the file?
I would assume so.
And Your Honor, I would offer this as State's Exhibit J.
Any objection?
If it's the same document we offer, I don't think so, Your Honor.
Isn't this different? I thought this was the alibi as to.
I have no objection, Your Honor.
All right, thank you. Please, you may. What's the exhibit number there from your file?
Letter J, Your Honor.
Say that again.
Letter J.
J, Exhibit J.
Yes, Judge.
All righty, thank you.
And so, Mr. Warren, you received this alibi defense that Philip Campbell was going to rely on an alibi that on October 30th, 1994, he was at 3957 Lafayette from 7 p.m. until 11 p.m. Is that correct?
Can you do me a favor?
Yes, Your Honor.
Advise the court of the relevance of Philip Campbell's attorney announcing alibi witness.
Your Honor, because the alibi witness is Philip Campbell, and he was charged as a co-defendant of Lamar Johnson, he noticed his alibi at 3957 Lafayette,
All right.
which was houses down from the alibi defense that Lamar Johnson noticed of. So we believe that that would be relevant for argument.
Show me what?
To
I
show,
mean, it sounds like these guys were trying to allege in their cases that they were in these two different places and couldn't admit the crime. Why am I to assume they should have both been in the same place?
Your Honor, we believe that it's relevant that Philip Campbell noticed up an alibi saying that he was intending on relying on the fact that he was incapable of committing the crime.
Right,
Someone was going to say that he was with them the night of the murder.
right,
Lamar Johnson noticed up an alibi down the block
right.
from his
okay.
co-defendant.
He lives in a different, or was staying in a different place.
He was visiting a different place.
Okay,
And subsequent to that notice of alibi, Philip Campbell entered a plea of guilty where he said that he committed the murder with Lamar Johnson. And so we are putting before the court those three pieces of evidence.
well, they don't do much because, you know, you're there on him swearing that he committed the crime with Lamar Johnson.
Correct, Your Honor.
The alibi thing, that almost hurts you because it's inconsistent. But it doesn't worry me too much because I'm not an issue as to whether or not he should have been crossed on filing an alibi defense and then saying that because he shouldn't, because it was a guilty plea, wasn't it?
Sure, Your Honor. And
Yeah.
I trust that the court will give it whatever weight the court believes it deserves, but I'm offering it.
Keep it at one page.
Yes, Your Honor.
All right.
It may be two to cover the plea, but I'll parse it down so it's not a packet.
All right.
So I would offer State's Exhibit J, which is 1 page.
All right. Thank you.
I can have just a moment, Judge. Your Honor, I have nothing further for this witness.
Redirect.
Yes, Your Honor.
You may inquire. Keep in mind that it's limited to the scope of cross.
I'm going to be short, Your Honor.
Thank you, sir.
Mr. Warren, I'll tell you that it's a fact, but you can assume this, that the deal that was made with Philip Campbell,
What?
the deal that was made with Philip Campbell,
Okay.
he pleaded guilty to 2 separate felonies. One, apparently the murder of Marcus Boyd,
Yes.
and he was stopped in a car with Lamar where there was a pistol found in the car. He apparently wasn't entitled to hold it. So he had 2 felonies he was pleading guilty to. The same felony that Mr. Lamar Johnson pleaded guilty to and got life without parole.
No,
Mr. Lamar
was
Johnson.
tried, wasn't he?
That Mr. Lamar Johnson pleaded guilty to and got...
Well, if
No,
he pled
Mr.
guilty, then
Johnson-
what are we having this for?
He didn't- I'm sorry. He didn't plead guilty.
Hold on, Counselor.
Yeah, let me correct it, Your Honor.
Right, thank you.
Thank you. This is the same crime that Lamar Johnson was convicted by a jury and received a sentence of life without parole.
The same homicide. is that-
Same context,
Yes, yes.
same crime.
Yes.
This guy has offered a deal for 7 years, plead the first to manslaughter. The second years was 2 years to run concurrent with the first 7 years. So he pleads guilty to 2 felonies. The first one, which got his co-defendant at the time, life without parole. This was a heck of a deal, wasn't it? This is a heck of a deal that was offered to Mr. Phil Campbell.
I assume so. It was the second day of trial, as I'm understanding, and Ed Sweeney was without a witness, so he had nothing to present.
I'm sorry, what does without a witness mean?
Yeah, what was
It
that?
means Elking might have deed-bound, gone away, fled.
So they couldn't find Elkie, so they made this deal with Campbell. Is that what your understanding was?
Is that what?
Is that what your understanding was?
That what?
Your understanding is that they couldn't find Elking, and therefore, for that reason, primarily, they made a deal with Campbell where he only pled guilty to 7 years.
That's what I understand, but that's based on triple, quadruple hearsay. I'm over in Europe somewhere.
I understand. That makes sense, doesn't it?
Yeah, it makes sense that if you don't have a case, you get whatever you can.
Yes.
Jeopardy had already attached, so
And
therefore,
so
the fact that we got that much is surprising.
So if you were a prisoner and facing life without parole, and somebody offered you a deal like this, and you were at the guilty plea hearing before Judge Berger, and they read as they did, Judge, strike that, Mr. Sweeney reads, in cause number 94-376B, the state would prove beyond a reasonable doubt on the evening of October 30, 1994, here in the city of St. Louis, state of Missouri, that at the street location of 3910 Louisiana, the defendant Philip Campbell, acting together with Lamar Johnson, arrived at that location. That 2 gentlemen were on the front porch, on the front porch or yard area of 3910 Louisiana. One of them being the victim, Marcus Boyd, and the other being a white male. That the defendant Philip Campbell, acting together with Lamar Johnson, caused the death of Marcus Boyd by shooting him, and did, the defendant knowing that the defendant's conduct was practically certain to cause the death of Marcus Boyd. Court, and those are the facts that the state would have been expected to prove. Mr. Sweeney, yes, just let me further state, the state would also prove that the testimony of the police officers and the medical examiner that the victim, Marcus Boyd, died from a final gunshot wound which entered the back of his neck and exited the front of his neck, and that in addition to that wound, he also suffered numerous other gunshot wounds to his body, being the upper part of his body and to his back and the left trunk of his body. 5 separate gunshot wounds to the left trunk and hip area. There was an addition wound to his arm that the medical examiner would testify appears to the continuation of the bullet that entered through his back, and a further gunshot wound to his thigh. And further, the evidence would be that the bullets received from both the victim's body and the scene, that there were 2 separate weapons, and the first a .25 caliber and the second a .38 caliber. Now, Mr. Campbell, do you admit that those facts, as stated by the Attorney General? Yes, ma'am. Has anyone made any threats or promises to you in order you to plead guilty? No, ma'am. Certainly made a promise that you only get 7 years for a murder and another crime. But anyway, are you pleading guilty of your own free will? Yes, ma'am. Now,
So what's the question?
would you take a deal like that, 7 years, and just agree to that? I would.
Well,
I have no further questions, Your Honor.
Yeah, I see where you're going. That's fine.
Your Honor, can I just correct one thing? I believe whenever Mr. Weiss was reading the plea transcript, he said, do you agree with the Attorney General? And it said circuit attorney. I just want to
After a few thousand of these guilty pleas, I kind of figured that one out. Go ahead. Anything further, this witness? Anything, anybody? You can step down, sir. See, I'm looking at 2:20. Is that clock correct? Yeah, it is, isn't it? Yeah. All right. I've heard you guys up a long time before I've allowed you to eat. Do you think you guys can eat what you're going to eat in 40 minutes? All right. Then let's name that tune in 40 minutes. Bailiff, 40-minute recess, 40 minutes.
All right, this is 17 is now in recess.